First of all, statistics is very bad about
Right.
appeals.
The likelihood of
Yes, the
prevailing.
likelihood is very low. Yeah.
Right, right.
If we're gonna get a RFE, I will be surprised. Yes, I got surprised.
Even if you fall out of status, some visa categories would allow you to refile here in the U.S. without having to leave even.
Maybe because they slowed down, because they really kind of slowed down. We file in mandamuses with our clients. Yeah.
NOID, you just might have to work a little bit faster and get. Good afternoon, everybody. My name's Charles Raether. I'm managing partner of AmLaw Group. And in today's episode, we're going to talk about something that's unpleasant but inevitable with any kind of immigration case. And that's what to do if you get an RFE, even worse, a NOID, or God forbid, a denial. And in fact, circumstances are not as bad as they seem if you have any of these results in the course of your casework with your attorney. And today we're going to go through some of these details and talk about why it's not the end of the road if you do get a NOID or even a denial. And here to help me out with that is Yulia Novik. Yulia, thanks for being here.
Hi, Charles. Thank you for having me.
Thank you. Yulia is our senior attorney here and has been with us a very long time. And the two of us, I think, hopefully can go through some of the details of what does it mean to get an RFE, a NOID, or a denial, what to do in those circumstances, and how to get out of that situation. And I think a lot of clients, when they first hear that word, especially denial, they're like, oh man, I'm screwed. And I guess we can't sugarcoat it. There's nothing good about getting a denial. But depending on the exact circumstances of the client, depending on the type of visa that they were applying for and other issues, getting a denial, much less a NOID or an RFE, doesn't necessarily, is not going to be as bad as maybe as it appears at first glance. So let's talk about these three options or these three outcomes that might occur short of getting an outright approval. And the vast majority of clients get approvals right away. Probably, I don't know, maybe 60, 70, 80% get approvals right away without any kind of RFEs or NOIDs and stuff like that. But let's break this down. We'll start with the easiest of the three options and go work our way up to the most difficult. So RFE, that stands for Request for Evidence. Depending on the type of visa, it can be more common than other ones. I don't know if you make a generalization, maybe 20 to 30%, would you say, people get RFEs? And all that is generally it's a request for additional information. Maybe in the context of particular visas, we could talk about this. So it's a request for information. So let's say if you're applying for a talent-based visa, EB-1A, NIW, they're most likely going to ask you questions about your accomplishments, your recognition, your experience, and stuff like that. What about in the scenario of an EB-5, Yulia? And I know this is a real general question, but what kind of questions do they ask if you've got an RFE?
Mostly those are the questions regarding the source of funds. Rarely we do get requests that are asking about project documents, which when we file through regional centers are easy to obtain from regional center if it's normal entity, of course. Yes, but mostly those are the questions regarding source of funds and path of funds.
So how do you reply? How do you prepare a response, or what do clients need to look out for when they're preparing a response to an RFE? I mean, what is the role of the attorney, I guess, in doing that?
Requests are usually written the way that even for us it's hard to understand.
That's true.
I know, Charles, that we quite often discuss what does this sentence mean.
Yeah. These are supposedly speakers of English, but you'd be surprised, I guess, sometimes.
Yes, and sometimes we had situations where we wrote in our answers that the question was not very clear. We assumed this is what you asked us.
Right.
And this is what we given you. Right. Yes, and even provide affidavits from ourselves that we don't understand the question.
Yeah, that's a good point. So maybe the initial role of the attorney is serving as a translator for the USCIS legalese, which I agree. A lot of times it's a lot of cut and paste. I don't think the officer himself knows what he or she is putting in there, and it doesn't make a lot of sense sometimes. But yes, you're right. It's reading what's in there, analyzing what they're asking for. And then, as you know, I think sometimes they will give examples of the documents they want, but we're not limited to what those
We're not
are.
limited to those documents. And sometimes they ask us irrelevant documents or even copy-paste from someone else's petitions. Yes, I had questions about grandparents and something like that where there was no relevance. So we need to point it out. But yeah, first of all, listen to your attorney when he interprets you, because the language in the RFE may be pretty confusing,
Right.
which happens most of the time.
That's a good point too. Yes, how the RFE is written and what in fact they're asking for can be different things, and it's based on years of experience. Okay, this is really what they mean when they're saying this, and so yes, that's why it's important working with an attorney to kind of again translate that into actionable items.
And another thing, at least I know about our office, at least I know how I work with my clients. I remember their petitions, and when something new comes up in one case, I know that the same most likely is going to come up in another case. And if we communicate with clients in between, and sometimes we do, I tell them, I warn them. And the same goes for filing the petition. Sometimes we know that we collected more or less all documents, but some we do not want to give right now, but we prepare them in advance. So be prepared for a fee. So whatever petition, whether it's EB5, any other petition, just know that there is a chance to get RFE, NOID, or denial. Denial is not going to come probably without any of those, but be prepared. So brainstorm what else they may ask you, and when you're waiting for RFE or approval, prepare some documents, collect them, so when you get whatever request you get, you're ready to just translate it.
And that's what we do a lot of times with our when we're developing the strategy with clients.
Yes.
We'll think about, okay, if we get an RFE and it's on this issue, can we get these documents? Will the client be able to give these to us? And we work accordingly. Yeah, so I would say the easiest is getting an RFE. It's no reason to get worried. Happens quite often, and we get approvals with the vast majority of RFEs that we get. So that's not too much of a problem. The next scenario is, what about a NOID? Notice of intent to deny. It sounds threatening, and in essence, I don't know what you think. I mean, a NOID is it's just a more serious RFE, I guess.
It's more pressure on us. Of course, even having the word deny gets you scared right away. And it's a lot of pressure because you have only 30 days and even sometimes less, depending when you get that letter to respond. And when you need to translate documents, so collect them from the client, strategize what you need, collect them from the client, meaning like if the client is going to be able, if he's even in that country from which he needs to get those documents right now.
Right.
Yeah.
Yeah, I would say the biggest challenge, like you mentioned, is the time pressure that they give you 30 days. And sure, we can do our work on our end within 30 days, but the challenge could be getting documents from the client, especially like you said, if they're overseas, getting them translated. That's where the time pressure comes on, and that's why maybe a NOID is more difficult than an RFE. Of course, like you said, it has the word deny in it, so it implies they're more inclined to deny it than approve it. So we're kind of behind the eight ball. We're going underwater a little bit. But again, I think historically, at least in our practice, we've been very successful in overcoming any NOIDs. But you said, I think the biggest challenge is that 30-day time frame that can really put pressure on everybody.
But my advice always try to respond. Do your best. And even if you know that you haven't answered all the questions, try to file it. And for attorneys, when you experience and you look at NOID and you see that whatever they're asking is not about this petition, they're mistaken, there is an error, we will point it in our answer, implying that you misread it, you misunderstood, and that's why basically you gave us NOID maybe and not RFE. So we didn't have enough time, although it was not our fault.
Right. The other thing too, you mentioned one interesting thing. I mean, there could be cases where we might not reply to an RFE or a NOID. That if we think, especially, I don't believe with EB5, I don't think we've ever done that. But with talent visas, I wouldn't say regularly, but it happens sometimes, right? That we feel we might have a very strong case. The client has a very good case, but the officer is just not buying it. They're really prejudiced towards the client, and we just might recall the petition. We've done that several occasions with great success. I mean, we've done it. We just recalled it and waited a couple of weeks, refiled it. Another officer gets it, and everything went through without a problem.
And I think with EB5, why we don't do it, it's probably because most of our clients are investing in regional centers, and regional centers are not going to give you money back unless you get a denial. Withdrawal is not going to work. So and you need to answer. So yeah.
Yeah, and they want to see that answer. Yeah, so yes, with EB-5, it's less of an option to just kind of pull out midstream. But with other visa applications, we could consider it. And then finally, if we look at it, the worst outcome is a denial. And I know it sounds maybe disingenuous, but I guess, and it's not good. It's never good getting a denial, but in some cases, it's not as bad as what clients think it could be. And again, it really depends on the type of visa. So, for example, let's start with the least harmful situations, especially with talent visas, right? You invested no money. Sure, you had to pay an attorney, you had to pay filing fees, but relative to some of these other categories, your investment was pretty small. And if you get a denial, and we've had some cases where we had really strong, EB-1A cases that we believed in the clients, and we said, look, we will refile this, and we would work out terms or something, or based on the results, that we felt so strongly that if any other officer would review it, they would approve it. And I think that's usually what's happened.
And it happens most of the time. Sometimes I think that the case is not so great, not so strong. It's not that the person doesn't have a talent. They just didn't collect all the documents that would prove their talent. So, but the case gets approved. And those cases, we had, I think, a few recently where I was sure that we're going to get approved. And I even told my colleagues that if we're going to get a RFE, I will be surprised. And yes, I got surprised.
Right. Yeah. So you never know what's going to happen,
Yeah.
right? So with the talent, that's with the talent visas. The more difficult side is I suppose with probably EB-5. That's probably the most difficult generally situation if you get a denial, because you've invested a lot of money, $800,000, and what are you going to do at that point? So fortunately we've had very rare circumstances where this has come up with denials in general and EB-5 in particular. How do we handle, or how do we tell a client to handle a denial if they had an EB-5 petition, for example?
As you said, Charles, we have very few cases like that. So it's hard even for me to remember much what we say, client. There is you always can file an appeal. Yes. But is it a good idea? It depends on the situation. Like maybe filing, like in other types of cases, is good, but you need to remember, if they denied you because of your source of funds, it's unlikely that you're going to return money right now for regional center and reinvest the same money, because it's going to come up in your new case and the officer is going to say, like, you reinvest in the same money.
Yeah, that's a good point. That's a good point, actually. Yeah, that I've thought about it. I think with our EB-5 clients, in those few cases where we have had denials, I don't think anybody has reinvested, even though they were all entitled to get their money back, right? Any regional center these days, they say, if you get a denial on your first green card, we'll give you your money back. So they could get that $800,000 back. Now, they can't just turn around and use that same money because it's just going to have the same problems as before. But if they got a different source, but the more I think about it, I don't think we've ever had a client for EB-5 that's gone ahead and reinvested.
Because you have to show the pass of funds. It's not that the officer just sees that you were denied and now you file a new EB-5 petition. It's okay. But you have to say, my money went where? Like, I invested in EB-5, then they returned me because I was denied.
Right.
It's right away, like.
Yeah, no, they'd have to get a whole new source of funds. And I guess for clients, it's burdensome, laborious, and something that they maybe not too interested in doing. For other visa categories, I think it's more common for them to refile because, again, there's no investment involved. You don't have to show path of funds, all these complications. So, and I can think of some cases we've had, certainly with EB-1A, where we got a denial. We were very shocked, and we might have just, tweaked a few things, refiled, and got approval. And I think one thing we want to emphasize maybe with our listeners is probably the least effective approach, depending on the situation, but generally the least effective approach is filing an appeal, right? I mean, appeal is just wasted time and money, don't you think?
Yeah. First of all, statistics is very bad about appeals.
Right. The likelihood of
the likelihood is very low. Yeah.
Right. And it takes forever. It can take years, 2, 3, 4 years for an appeal. So that's why I think with our clients, where we think it's worthwhile, we would say, hey, forget about the appeal. Let's just refile.
Yeah, refiling is in cases, but again, there are not too many immigrant categories. If we're talking immigrant petitions, mostly it's EB-1A. When you're refiling, you're just supplementing a little.
Right.
You're not changing. You're staying talented in the same field. Maybe you decide to participate in new competition. Maybe you already did.
Get some
So
new
you just
awards. Yeah.
supplementing.
But if it's like a different one, let's say EB1A, and if it's an EB1A denial, it's likely because they didn't show their executive capacity, or
EB1C,
maybe,
Charles.
I'm sorry, yeah, EB1C, their executive capacity, or maybe they didn't have enough subordinates. And that's relatively easy to solve, right? You can hire some more people, change the capacity. That might take a little time, might take 3-6 months.
But usually, yes, when you file in with experienced attorney and they know, usually RFE is the most subjective, meaning executive capacity, which is there are 4 sentences what it means, but you have to give so many details what you do. But yeah, you rewrite it. If you on RFE, if you get denied, you basically refile it.
So one unique situation, I think, Yulia, that we need to discuss is a denial at the embassy, because that's a totally different ballpark or situation scenario than, say, you got a denial from USCIS. And where that can occur, now it's theoretically possible that you could have gotten approval from USCIS for any kind of immigrant visa, EB1A, EB5, and you get to the embassy and they could review it a second time and deny you there at the embassy. That's a unique situation. It's very unusual, I think, so we're not going to maybe focus on that. But what I wanted to talk about is a situation where you file directly with the embassy, and that's with a E2, as we all know. And so with the E2, that can be a challenge because, first of all, they don't even issue an RFE or a NOID. So they don't give you any feedback. Hey, we don't believe you about this. We need some more evidence here. I mean, usually if they just don't like it for whatever reason, you get the denial right there.
And they just communicate with the client over there on interview.
They don't even bother to talk to the lawyers.
Yes,
Can you imagine
they don't
that?
even bother. We cannot even write to them.
Yeah, so it's a challenge for our clients and for us as well, working with the embassies, because it's a snap decision. They go in for that interview. It could be 5-10 minutes. That's it, and the officer makes a decision right there. And as you and I both know, probably 95, maybe 99% of the time for an E2 denial, it's a 214B, right? It's the article that says, well, we think you have immigrant intent. Whether that's really true or not, who knows? But that's the easiest reason for them to pick to deny a client of an E2.
And it happened, Charles, even in cases like O1, where USCIS actually approved the petition. A few years ago, it was happening, and I was talking to other colleagues, and it was one after another. We were discussing which embassy it was, where to go afterwards, because the petition is approved.
So in the case if you get a denial for an E2 at the embassy, that's a little bit more problematic because it's difficult to overcome that finding of immigrant intent. So again, we're talking primarily about E2s, and again, primarily about immigrant intent, because I rarely, if ever, have seen, maybe we've had one denial where it wasn't based on immigrant intent. It might have been based on source of funds or something related to that. And it's really tough to overcome that it's almost like I don't know, you're blacklisted, right? You basically are kind of, they put a scarlet letter on you saying, hey, you have immigrant intent. You're not good enough for an E2 or similar non-immigrant visa.
And what's sad, we know that this happened with clients where we told them, we know that Foreign Affairs Manual, for example, says, yes, for E2, you need to have an intent to go back to your country. But the Foreign Affairs Manual says you don't need to maintain property over there. Right. You can sell your real estate, you can rent it out. You just need a letter stating, yes, I intend.
Right.
But they don't use it. The officers don't.
No, yeah, they don't. So that might be a scenario. So that's a scenario. I would say, so we're putting a somewhat positive spin on getting denials. And I understand I say this tongue in cheek, because it's not a good thing if you do get a denial. But again, we'll get back to this discussion about denials, how to deal with them. But I have to agree, if you do get a denial with an E2 at the embassy, then it's a challenge, right? You're going to probably have to wait a while to refile. We might have to consider filing for a different visa type.
Or immigrant visa.
Well, yeah, or it could be an L1 sometimes. That's a good follow-up or step back or fallback option, right? So if you get a denial with an E2, if you do have a business, you have a qualifying business, again, it's similar to an E2. The L1 is a little better in the sense that they can't deny you for immigrant intent.
It's dual intent.
Yeah, it's a dual intent visa. So yes, that could work. So we have to do a little bit more strategizing with a denial at the embassy with an E2. So that's a separate case. I just kind of wanted to highlight that. But if we get back then to getting denials in the U.S. through USCIS, what's the best course of action, do you think? Well, let me ask you this question. Let's do some scenario role playing here. What if we have an EB-5 client and they get a denial? What's the best course of action that they could take?
Rarely I can say go to court, because to get to court will take you time. You have to exhaust all administrative procedures. So you have to file a motion to reopen or reconsider or appeal. It takes time. We don't know how long. And if they deny you, then only after that you can go to court.
Right.
But it takes time. You have to be very confident that you really provided all the documents for the petition. So probably refiling. But with EB-5, it's way more challenging than with other petitions. And probably that's why they're most difficult cases. It's not just the amount of investment that people have to put somewhere. It's not just their money, it's time sensitive. And if you denied, what is the other option? As a petition?
Right. Absolutely. Well, so EB-5 is probably the most difficult case to refile or redo, just because of the complications. You got to get your money back from the regional center, which any regional center these days will return your money. But then you have to come up with new money to invest, because obviously there were problems with that old money. That's why most likely you got the denial. Now you have to get some new money to reinvest in a new project. So EB-5 can be a challenge if you do get a denial. There could be alternatives that you could look at. But let's say, even if you got, let's say, I don't know, EB-1A, you get a denial. I mean, you could refile.
You can refile. With EB-5, I think you have to strategize at the beginning, have other options. But again, most of the time where there is a RFE or NOID, those are not the bad cases, not the weak cases that we predicted. Those are pretty strong cases. But every time, I still think when you file in EB-5, have in mind something. Maybe you have time to collect documents for other immigrant petition, because refiling EB-5 is complex.
But I think one thing I should say that to console our listeners is something we brought up in an earlier podcast, that the recent statistics are showing that 97% of the 526s are getting approved. So your chances...
I'm still not believing that.
Yeah, Yulia doesn't believe that. But yeah, 90. So if you're one of the 3%ers...
maybe because they slowed down, because they really kind of slowed down. We file in mandamuses with our clients.
Yeah, that's possible. It's possible. But so if you just look at the statistics, at least how they're published, your chances are very high that you're not even going to get a denial with the EB-5. And like, for example, with the L1s, and we don't have time maybe to go through all these options, but if you get a denial in the U.S. with an E2 or an L1, you generally, again, depending on the reasons for the denial, it might not be too difficult to tweak some things, change some things with your business, hire more employees, maybe, change some other things with your operations, and then refile.
You just start early. You have 90 days till expiration of your previous status, because when you come in here in tourist status, you have only 180 days. And first 180 days, you kind of not, or first 90 days, you're not supposed to file for change or extension of status. So you have a 90-day window. File it as early as day 91, and most likely premium processing. So you have time to refile.
Right. And that's a good point too. That is, as long as you still have some time available, you might get a denial within 15 days, 30 days after that. You still have maybe 1 or 2 months to collect any needed data, restructure your case, and go from there and refile. So hopefully this puts some people at ease that certainly if you get an RFE, absolutely nothing to worry about. NOID, you just might have to work a little bit faster and get your lawyer moving faster. Denial, of course, not pleasant, not great, but hopefully we're able to go over some of the options that you could pursue. That it's not the end of the world. There are options, and even if you fall out of status, some visa categories would allow you to refile here in the U.S. without having to leave even. So there usually are options.
There are. You just need to strategize.
That's right. Make sure you do it.
Talk to your attorney. Ask what will happen, what is possible, because everything is possible. and be prepared. Maybe don't file, if you file an immigrant petition, don't count on filing adjustment and staying here for a few years without a problem, because yes, you can stay, but if you get denial in your petition, then you have no status, you have to leave the country. And after living here for a few years, having like house, kids going to school, it's difficult. So strategize from the beginning and ask questions.
Yep. Plan out. Have a good plan at the beginning, just
Yes.
For a plan B. So hopefully that was. Thank you again, Yulia, for your time and everything. And hopefully these issues and answers that we provided will help you as well in terms of coming up with effective transition plans to come to the U.S. and how to best react when things don't quite go as planned. Thank you again.